Good morning, and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, and I am here every Sunday from 8 to 9 on these stations to give landowners valuable information you need regarding natural gas development here in Pennsylvania. At the Clark Law Firm, my focus is solely on landowner representation. I represent landowners and only landowners. I do not represent, have not, and will not represent gas companies, pipeline companies, or any company involved in the natural gas development process. My focus is solely on the landowner, and we need more people focused on the landowner. I represent landowners for gas lease negotiations, pipeline right-of-way agreements, well pad agreements, royalty issues, royalty deduction issues, unitization issues, estate planning. As you know, really transitioning to do more and more estate planning for clients who have been longtime clients who are starting to get royalties from the oil and gas lease and realizing, hey, want to make sure we get a good plan in place, want to make sure that I have my children covered. Maybe you have some charitable organizations that you want to take care of. We want to make sure that you have a plan for you, for not for your neighbor, but for you. Do a lot too with the unitization issues, where maybe there's a issue regarding whether your property was appropriately unitized, whether you're not being credited appropriately with the amount of acres that should be credited to you within a unit. Doing a lot of that work as well. Surface use agreements, well pad agreements, meter sites, compressor station agreements. All of these type of issues and many, many, many more. So if you need representation, the idea of the show is not to be just a big commercial, but you can always contact me directly at 570-307-0702. And that goes for the entire state of Pennsylvania. If you have gas rights, if you have land anywhere in Pennsylvania and you need assistance, feel free to give me a call and see if I'm the guy and the Clark Law Firm is the right firm for you. You know, I just had some new clients this week from Texas who have gas rights, family, and it's an interesting thing. I mean, can you imagine you're sitting somewhere, you're sitting on your couch, you get a call, it's someone on the phone saying, oh, by the way, your great-great-grandfather reserved oil and gas rights in Pennsylvania, and you actually have a 1 out of 25 interest. So there's 25 siblings that have, relatives, not siblings, that have an interest, and you happen to be one of them. So we'd like to enter into an oil and gas lease. And their first question is always, who is this? Is this for real? But it does happen. So they'll go online, and that leads me right into check out our websites. Very important. Whether you need representation, whether you're looking for information, pagasleaseattorney.com. I really think that's a great place to start. pagasleaseattorney.com, pipelineattorney.com, two websites, just revamped, renovated, pagasleaseattorney.com. Thank you for the people. We've getting people writing in, complimenting, calling. We really appreciate that, and I mean that sincerely. There was a lot of work involved in getting the site up. Working on some new articles that I'm going to be posting in the blog section. You can sign up if you want. You can be a part of the website. You can get a newsletter. Check out the testimonials. We have 100 plus testimonials written by former clients. So check that out as well. And the point there is one thing I would say is you need as a landowner to be comfortable with whoever's going to represent you. You need to have an attorney who you feel comfortable with, that you have trust in, that you know is experienced, and you know how have they treated other people and what is the feedback from other people. So I think that's a very big part of the website, especially a lot of my clients, we don't meet face to face. Just explained, I have these clients in Texas now. I won't ever meet them unless they decide they want to come up to meet me, but it's unnecessary. They don't need to come see me, and I don't need to see them. If we need to ever Skype or do anything electronically, we can. But generally speaking, emails, telephone calls work out great. Just finishing a very big case in Greene County, which is the county in the most southwestern part of the state, right against West Virginia and Ohio. working actively on an Allegheny County client, many clients I have in the western part of the state as well. So, don't be discouraged. If you are interested in learning more, please feel free to contact the office, 570-307-0702. Doing a lot of these FERC pipelines. I think I probably got maybe 5 calls or even more this week from people who are very upset, and understandably so, because they've been notified that a pipeline company wants to come in and going to put a pipeline in. And a lot of times, with these FERC lines, there's an art to how you do this. Generally speaking, people are not going to be happy, generally speaking, but we want to make it the best we can out of that situation. So you don't want to just say, oh, they're going to get it anyway, where do I sign? We want to make sure that we're maximizing this situation to make the best of what is often a bad situation, but we want to make the best of this situation, which could be tens of thousands of dollars and more compensation. It could be to draft and construct a better pipeline right-of-way agreement. One of the things, too, I'll talk about often is, in doing this so long and just doing this, one of the things that comes up is I'm working on some of these new FERC lines now. Well, what happens is I have some other people who are coming to me and have come to me, and they say, well, my parents signed a pipeline right-of-way agreement in 1950, and now the company's coming back to put a second pipeline in or to do something different in this pipeline right-of-way easement area that my parents signed for years and years ago. So as you go through this process, I'm constantly learning as well. I've already learned a lot, but I'm still learning. I mean, you have to always be learning to do better. So I see what these problems are, and I see what the people are struggling with who have bad pipeline agreements on these major interstate pipelines that were entered into 50, 60, 70 years ago, maybe 30 or even 20 years ago. So what do? We learn from that. And when we're drafting and working on new agreements, we're trying to tighten them up and prevent these problems in the future for the landowner who's now presented with a new agreement. Happens all the time, whether that be in leasing, just regular pipelines, meter sites, compressor sites. When people come to me with a problem, well, not only do we try to resolve and correct or fix this problem if at all possible, we also learn, hey, this person has a problem. And the reason why they have this problem is because the way the original contract is written. So as I work on these types of contracts, the type of original contract that gave this new person a problem, so whether it be a pipeline, a lease, whatever the case may be, we learn from that. And we say, okay, well, I'm aware of other people having problems with this language or this type of agreement. So what are we going to do? We're going to look to correct that with a new client who's presented with that same type of agreement. Hope that makes sense. And it's a little abstract, but it's really important. We're learning. I'm learning by looking at problems that other people have from older agreements, and we're trying to correct those whenever the new client has the same type of agreement that was signed years ago. So to put an agreement, just like I said, take a pipeline right-of-way agreement. Somebody signed the agreement, whether it be 2000 or 1950. Now they're having a problem. We see what that problem is. I'm working on a new pipeline agreement with an interstate pipeline or even a regular pipeline company, a gathering and transmission line. What do? I say, okay, well, I'm aware of all of these different problems that people have had, so let's try to draft these new documents when now that the new person is presented with the pipeline agreement. We can't go back in time, but what we can do is strengthen the new agreement and attempt to avoid these problems. I am Attorney Doug Clark. You're listening to All Things Marcellus. I'm here every Sunday from 8 to 9 a.m. I talked about the radio show I talked about the website. Well, the radio shows are on the website as well. So you can go back, and I've been doing the show since August of 2010. Weekly radio show since August 2010. Go check out pagasleaseattorney.com. You can see or listen to you can see them, but you can listen to the older radio shows. And because we just revamped the site, we're still uploading the shows. It takes some time. There's a process to that. But many of the shows are up. We have like 150 to 200 shows that will be up. So 150 hours plus, closing in on 200 hours of radio show that you can listen to. But remember, be careful you're not listening to older shows and applying those to your situation today, because a lot of this information is very time sensitive. So what have I done? And I shouldn't say it, not that I'm some kind of genius, but what have I done? Well, what have we done? We've taken the show. We're now posting them on the website the following day. So you're listening to this on Sunday morning. You can go to the website, pagasleaseattorney.com, on Monday morning and listen to the show if you missed any of it. Listen to last week's show and the week before that and so on. So you can also actually go to YouTube, but really encourage you, check out pagasleaseattorney.com. Quite frankly, I'm really proud of the website, put a lot of work in. My thanks to the guys at Lock Data who worked with me on the site. Really like it. So if you haven't seen the site, maybe you saw the old site at pagasleaseattorney.com, really encourage you, check out the new site. So I want to go back. I said about me learning, always learning and learning from other mistakes that other people have made, or mistakes maybe that we've made, that I've made. Nobody is perfect. So if we find a situation where a company has exploited an older lease or an older pipeline agreement, well, what do? We try to correct that the next time we do an agreement. So especially some of these real old ones, there are a lot of problems there. So you can't make these same mistakes, or else it might be you in 5 years coming back and saying, hey, look, I have a problem. Maybe it's your children in 25 years or 50 years. Let's get this thing done right. And there's also a compensation aspect to this, where maybe you're leaving tens of thousands of dollars on the table that you might have been able to obtain. Everybody, probably 90%, now 95% of the people that I deal with, and I enjoy dealing with these people, I enjoy dealing with everyone, say, hey, look, it's not about the money. It's not about the money. And I understand that. But there's always a money aspect. So if you could get an agreement that protected your property the way you wanted to protect it, and the company said, okay, we'll give you $50,000 for this agreement, and you're happy the way it protects your property. Well, would you not prefer if you had the same exact agreement and the company said, we'll give you $100,000 for that agreement? Well, yeah, it's the same agreement and it's for more money. So if I can get you more money and get you the best possible agreement, it may not be about the money, but hey, that money is a good thing to get. We want to make sure that we're getting you the most compensation, but also the best possible agreement. And it's always the landowner's decision whether to proceed or not to proceed. And think about this, when you're dealing with that landman, is his motivation to give you the best possible agreement for you? Is his motivation or her motivation to give you the most possible money? Certainly it is not. Remember that, please, people. Please, please, please remember that. Finally, before I go into break, I said we're always looking at older agreements. We're seeing where companies have been able to exploit some of those terms. Well, think about this. Companies have obtained a lot more experience over the last century in doing these agreements. So anytime that agreement has been written and the company goes and they want to operate or do something in the future, and they have some restrictions in the lease or in the pipeline agreement that they don't like, well, what do? They change it for every other lease or pipeline agreement moving forward. They're on a whole different scale, and this isn't just at Pennsylvania, this is across the country. So they have the ultimate base of information in history, and so every new agreement, or every so often, you'll see, well, all of a sudden something changed in their standard form agreement. Well, why did that change? Because they found when they were using their old form agreement that something in there gave them a problem. So what did they do? Well, they took it out or they changed it. You got to understand that. So what do? We can still combat that. And I haven't, I don't know if there's been a form agreement that a company has ever presented to the landowner that I've not been able to negotiate to make it better for the landowner. And in the vast majority of cases, in most cases, we are able to get more compensation too. Okay, I'm going to get back. I'm going to talk. I'm excited about this show here. I'm going to talk some things. I'm going to probably go a little bit on a rant, but stay tuned. I'm going to talk about some more, some well sites. I want to talk about some compensation. I want to talk about some Tioga County development. I'll be right back after this break. You're listening to All Things Marcellus with me, Attorney Doug Clark, and I am here every Sunday from 8 to 9 a.m. Welcome back to All Things Marcellus with me, Attorney Doug Clark. Again, I'm here every Sunday from 8 to 9 a.m. Check out, if you miss any shows, you want to check out old prior radio shows, pagasleaseattorney.com is the place to go. Also, check out pipelineattorney.com. We, as I've said, renovated the pagasleaseattorney.com. Got to check that out. Working on the pipelineattorney.com website, doing the same type of thing, an overall renovation, and probably within the next month or so, that's going to be up and all new as well. So really excited about that. But quite frankly, doing all the work on the PA Gas Lease Attorney site has set me back a bit. So I'm working on the pipeline site, but I'm also working obviously on my my regular clients as well. So okay, I want to talk about some things, and I can see myself. Here's the thing: stay tuned if you want to hear me rant a little bit. I'm going to probably do that in the last segment here today, and do some ranting about. I'm going to attack some landman, or not a specific landman, but attack the landman a little bit, and a little bit to the landowner. We got to be smarter. We have to be smarter. We have to learn. We have to learn from our own personal experiences. And like I said in the last segment, we can learn from other people's experience as well. We have to do that. We have to. And it just kills me because I see so many people are not doing that and not taking advantages of opportunity or advantage of opportunities that you have or may have, and not simply saying no and still being tricked or bullied and doing things that just simply either aren't in their best interest or are out there that you could get a lot more money for. Like I said that first segment, it's not about the money. It's not about the money. Well, a couple things then. Well, why are you doing it? In part, you didn't sign a gas lease because you just wanted a company to tear up your property, did you? Well, no, you signed it because in part you wanted to see some sort of compensation. So now something else comes in and there's another agreement. Well, again, are you just signing this so they'll tear up your property? Well, no, at some point you're executing these agreements, you're entering into these agreements for the idea of future royalties and financial benefit. At the same time, we can protect your property and maximize the agreement. Get the best agreement to protect your property, to limit what the company can do, and at the same time, work to get you more money. That is what you need to do in all these cases. Okay, I'm not going all the way there yet. So I want to talk about, I'm kind of going to do a little bit here of ranting. I'm even going to rant some on attorneys as well. So, okay, a client comes to me. There's a lot of development, and it's on the cusp. You're going to see a lot more in Tioga County. And we got Southwestern really buying up leases and properties from other companies and gas rights. And so we're starting to see, and I think we're going to see more. I see so much development on the ground now and have clients in negotiations with Southwestern, Angelina Gathering Company, which is a pipeline company affiliated with Southwestern, DTE, Bluestone, Susquehanna Gathering, Williams, doing so much pipeline work, and this is in the northeastern part of the state. Well, we're starting to see Tioga County become more and more developed, and we're still early on in this process. And there's been some exchange, like I said, of leases where Southwestern has purchased leases. So I've been doing a lot of work with Southwestern on well site agreements, roadways, pipelines. I'm going to interject here, whether it's me or somebody else, please, please, please do not just sign these agreements. Do not just sign these agreements. get an attorney, get somebody this experience, and I'm going to talk about that now. So I have this client, new client, and I don't want to get too specific, but there's a lot of acreage involved in this particular case. So they had some good leverage. Sometimes that comes into play, sometimes it doesn't. You got to look at every case individually. But this happened to be a fairly large acre, actually not even fairly, a larger acre client, no doubt. So, and you see, out in Tioga County, there's a lot of hunting clubs. So I've represented many hunting clubs and continue to represent a few at the present time. I think I have 3 or 4 active hunting clubs in negotiations right now. So anyway, this client has a lot of acreage in Tioga County. And so what we see is now I wasn't, and I wish not for me so much as I wish for this client that we would have talked before they executed their oil and gas lease, because now they're coming to me to represent them because now the company has approached them to actually develop the property. Good thing, whether it's me or somebody else, when you're approached to develop your property, contact an attorney who's experienced, who understands, who can help you. Unfortunately, these guys didn't contact me or an experienced attorney whenever they were entering into the gas lease. This particular client is very concerned about the development of the property. And as are most people, very common sense, most people are very concerned. They don't want to see their property destroyed. They want to either hunt, they want to use it for recreation, or maybe they live on the property. Very, very common sense. Most people don't care, most people care about the impact on their property. There are occasional people I deal with. I have one client now down in Florida. He hasn't seen this property in years, and my directive is, hey, get all the money you can for every agreement you can, and I don't care so much about protecting my property. That's very, very rare, but still, we can protect the property and still maximize compensation. It is a rare case where a company says, well, if you put no addendum in this agreement, we're going to give you more money. Landmen may try to act that way. Again, landmen may, I hear this all the time. It's so funny to me because I hear it all the time and I deal with so many people. Well, we can't say how much money we're going to give until we see what type of addendum terms or additional requests you're going to add. Well, that's generally just garbage. That's a way for them to try to intimidate you as the landowner, or try to intimidate me as a lawyer, to say, well, I'm not going to ask for as much because, that may reduce the price. That is garbage. That's just absolute garbage. Don't fall for it. Do not fall for it. If they say to you, well, we may be able to offer you more, but we have to see what you ask for. Well, you know what? If you listen to that and you believe that at all, you just fell into the trap. One of the many traps. That's the trap to intimidate you, not in a strong way, but to intimidate you in some fashion, not to ask for as many property protections that you might have otherwise asked for because you're afraid they're going to take away money. Generally speaking, that simply does not occur. As a general rule, that doesn't occur. But it's a very effective tool for the landman to say to the landowner, and now, instead of the landowner asking for certain limitations that they could easily obtain, they don't ask for them. And now they have an inferior agreement and did not maximize their situation. Do not fall for that trap. I am Attorney Doug Clark. You're listening to All Things Marcellus. I am here every Sunday from 8 to 9 a.m. And I want to reset here. So I got this big client, a big acreage client, not necessarily a large individual, but a big acre client in Tioga County. So they now are approached by a company to develop their property in Susquehanna County. So the first thing I say is, okay, I need to see your oil and gas lease. And they entered into this oil and gas lease fairly recently. I was not involved in that process. So we say, okay, well, you're going to put a well pad in the property. You're going to put a roadway you're requesting the company is. Let's see what these rights are. And again, for this landowner, I know in our communications that input on location for a well pad or access road, the ability to have communications and have input as to where activity is going to be located on the property is very important to this landowner. It's usually important to all landowners, or almost all, but it's especially important in this particular case. So we say, okay, let's look at your rights. Let's see what you have. Let's see what's in the lease. If you're a regular listener, you know how many times do I say your lease, your gas lease, is your foundation, the blueprint, the rule book, setting forth the rules of what's going to occur in the future. And I don't care what the company says, if you don't have something in your lease and the company doesn't want to do it, I can assure you, I've dealt with this hundreds of times, they're not going to do it. So, okay. So I get this lease, and here's the provision. And I read this, and it just drives me insane, or close to insane. All right, so it says that, essentially, I'm going to paraphrase the beginning, that anything to the contrary that's in this lease, meaning despite anything else in the lease, prior to the company exercising its right to use any portion of the surface of the property for the purpose of the lease, the company must first obtain the approval of the lessor. Well, we love that, but no company's going to say, unless you have a complete no surface lease, which is possible, which is something everybody should at least explore, you're going to see that the next sentence is going to be involved in 95% of the leases. So the company must get your approval before operating on the property. But it says such approval shall not be unreasonably withheld and shall be granted in a timely manner. So, saying gas company says, if I'm going to operate on your property, and this is in your lease, and this is an addendum that was added to the lease, if we're going to operate on the property, we agree that we must get your approval, but you can't unreasonably withhold your approval, and you can't unreasonably delay your time frame for giving approval. So, and now look, that makes sense. There's many terms out there like that. Company says, hey, we want to put a well pad there. You say no, and they say, okay, well, where do you want it? You say, I want it on the cliff in the back. And they say, look, we can't build a well pad on the cliff. Or you say, hey, I want it in the swamp in the back that is all the way in the back of the property. They say, look, we can't construct a well pad in the swamp due to all the wetlands. And so you're going to have problems there. So if you say to them, I don't want it, or you just simply say, I don't want it, I don't want it, I don't want it. Well, they say, hey, look, tell us where else you want it. And they say, I don't want it anywhere. And they say, well, look, you're being unreasonable. You had signed a lease that said we could put a pad on your property, and now you're being unreasonable. So, therefore, we're going to go ahead and do it and essentially try to stop us. The next part would be, well, they ask you to put a pad in the property and you don't respond. They say, hey, here's the plan. We want to put a pad in your property, and you just sit there quietly and never answer. Well, a certain amount of time goes by. Maybe it's a month, maybe it's 2 months, 6 months. They say, look, you've unreasonably withheld your consent as far as the time frame goes. You can't just ignore us. You have to communicate. So those things, yeah, they tend to make sense. What you have is, you have leases where you have complete no surface lease. You can't touch my property. And you have leases that say you can touch my property essentially anywhere you want as long as you meet the state law, set back some houses and water and things like that. So those are, full access leases. Then you have this middle area where you may have something like, hey, you can use my property, but you must get my consent. However, I acknowledge I can't unreasonably withhold my consent or delay it. So at least we have some discussion or input, and we can work on location. So if you want to put it in my backyard, 501 feet from my house, well, maybe I can say, no, I don't want it there. Let's shift it somewhere else that's going to be more convenient for me. So it can work, and it can be a problem at times if you don't like the location and the company says you're being unreasonable, then, well, you may have a problem, but it's a lot better, in my opinion, than simply having a full access lease. However, there's more to this provision. There's more to this provision, and from my perspective in representing the landowner, there really shouldn't be more to this provision. I'm up against this break. I'm going to talk about it. We're going to talk about the rest of this provision, and it's going to give you some ideas of how that interaction with the landman goes, how you think you're getting something when in reality you're getting little to nothing, and then this was reviewed by an attorney who didn't inform these people, these landowners or this landowner, what the problem was with this language. I'm going to explain it all right after this break. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, here every Sunday from 8 to 9. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, here every Sunday from 8 to 9 a.m. And if you miss any of today's shows or any show dating back to August of 2010, you can go check out the website, pagasleaseattorney.com. Check out YouTube. However, I have to say that's a bit misleading because we're still updating, putting up the older shows on a website as we revamped and renovated pagasleaseattorney.com. But check out the site, sign up for the newsletter, check out the blog, follow me on Twitter. I come across articles. It's at Doug Clark Law. I do a lot of tweeting of articles that I think are interesting. People should be aware of. People send me articles. I tweet them out. I read articles. So you can follow us on Twitter and Facebook as well in the Clark Law Firm. So check that out. Okay. Talking about, I'm going to reset quickly. We got a client. I have a client in Tioga County, very concerned about well development on their property, surface locations. Where is it going to be located? Where is the activity going to occur? They want to have a lot of input. Unfortunately, I didn't deal with them, wasn't retained, and they hadn't talked to me about the gas lease. But now that they've been approached by the company to develop the property, they've given me a call, and I'm going to be representing them, or I'm representing them, relative to this development of the property. Get the oil and gas lease and say, okay, what are the terms? And I said the beginning part, addendum, which was negotiated. So the landman is negotiating this with the landowner. And the landowner certainly has the impression that this term has some value. And the landman certainly isn't going to break this down as to why there's major problems in this term for the landowner. Now, here we go. So the beginning part says that before the company can conduct any operations on the surface of the property, they have to consult and communicate with the landowner to get their mutual consent. Where are these operations going to occur? However, the landowner cannot be unreasonable in granting consent. Can't simply just say no, no, no. Maybe you say, well, okay, I don't want this operation here, but can you shift it over here further from my house, or can you take it away from my best farmland? Maybe your best hunting area, maybe an area that you're going to create or considering you could subdivide the property. You have some nice road frontage that, hey, I'd like to shift this, and I have good, solid reasons to do that. So I'm not being unreasonable. Here's the reasons why. And also, you can't unreasonably delay consent or approval. So you can't be notified, hey, I want to put a well pad. A company says, we want to put a well pad on your property, but you never respond, and because you don't want it, you just simply hide in the closet. Well, that's not going to work for you. So that's pretty standard. So again, no operations on the property unless the landowner consents, but the landowner cannot unreasonably withhold or delay their consent. But this goes on. It then goes on to state that failure of the landowner to propose an alternative location. Okay, so I'm going to stop there because it's really important. So we said you're asked to put a pad site in a certain spot. Maybe it's really close to your house. You say, look, I don't want it there. Here's an alternative location. We'd like to use this alternative. Here's an alternate location. Put it in the back of the property so I don't see it. It would be much better back there. Okay. Well, that's reasonable to offer an alternative or alternate location. Okay, that's reasonable, and you need to submit that. So I'm okay so far. So failure of lessor or landowner to propose an alternative location. Here's where it gets super problematic. In compliance with all applicable governmental regulation and laws. Now, you have to present an alternative location that is in compliance with all applicable governmental regulation and laws. Do you know those? Do you have any idea what those limitations are? Do you have any idea what you're going to do is you're going to say, okay, well, I want to have it over here. Please put it back in this area. Well, if there's a wetland in that area, which there are many wetlands, and if this is a 10-acre, 15-acre, or even 20-acre well pad and access road, the chances of there being a wetland in the area which you're going to recommend to shift the pad site is very, very high. Probably closing in on 100% high. So you have to present an alternative location that applies with all applicable government regulation and laws, but that's not enough either. It goes on to say, and suitable to the scope of the gas company's proposed operation. So now you say, okay, I don't like this site, it's in my backyard. I don't like this site, it's in my best hunting area. I don't like this site, it's going to take up this road frontage and definitely devalue my property in the future. So I don't want it there. What do I have to do? I have to now present an alternative location that complies with all governmental regulations and laws, and that this location is suitable to the scope of the gas company's operation that they had planned. So if your alternative location makes it a more difficult process, the company can probably just say, no, we'll have to use some more acreage. This will require more work. Also, there's some wetlands there. That location isn't going to work. The chances of you being as a landowner, in my opinion, the chances of you to being able to provide, to meet this term, to provide an alternative location that complies with all governmental rules and regulations. So if you have one little wetland in there, that could be the company's way out. But also suitable to the scope of the company's operations. So again, if it's going to involve more of a hillside or a big, it's going to require a bigger area, that may be an out for the company. The chances of you as a landowner being able to fulfill that particular requirement is unbelievably small. In my opinion, very close to being zero if the company doesn't want to be flexible. And in most cases, they're not going to be. So it just guts it. It just guts this whole provision, is gutted with these sentences. And then it goes, or this clause, and then it goes on to say that not only do you have to present this, and it has to be follow all, or it has to be in compliance with all applicable governmental regulations and laws and suitable to the scope of the gas company's operations, but you also have to do this within 15 days of the gas company notifying you that they want to construct a well site, an access road, a pipeline, or whatever other facility. So now that you didn't have enough to somehow try to comply with governmental regulations and laws, which you don't even know what they are, then your presentation of an alternative site has to be suitable in scope, so about the same thing, and you have to be reasonable. You have to do all these things in 15 days once you receive notice. How are you realistically ever going to meet that term? So now, gas company guy knocks on the door, says, hey, we want to put a well pad on the property. The landman comes and you say, well, geez, I don't like that. Well, they say, hey, under your lease, you do have consent, but you can't unreasonably withhold it. You got 15 days. You have to provide us an alternative location. Which, remember, some of these are 15, 20 acres in size. You have to provide us an alternative location, similar in scope, that complies with all governmental regulations and laws. And as part of this, too, there's a correspondence from the company to my now client landowner indicating that if there is these other locations that you must submit as a landowner to the company, and this location, listen to this phrasing, this location must be at least as acceptable to the gas company as the one that the gas company chose and submits to you. And it has to be least as acceptable, meaning that it has to be at least this good. So you have to present them something that's either as good as what they've given you as far as the gas company's proposal is from in their minds. It has to be at least that good or better as it relates to constructability and accessibility. So I don't know how anybody is going to be able to meet this term to move a well pad. It's unbelievably burdensome. So to me, had this landowner brought this provision to me and said, hey, we're concerned about operations on the property, and clearly they are because they think they have something that has some teeth to it, the reality is they have almost nothing. And I believe that. And the problem here is the landman that negotiated this with them, he certainly didn't say, hey, by the way, this mutual consent provision, it doesn't mean anything because you'll never be able to comply with this provision. This addendum that I'm giving you because, we want to work with you. We want to be good neighbors. We want you to have input, all those things. Well, the reality is it may look good at first glance, but read it and understand it, and it means next to nothing. The landman doesn't work for you. He works for the company. He's not trying to limit the company's authority or ability to work on your property. Now here he is, same guy knocking on the door again saying, "Oh, we're going to operate on your property now. Oh, and by the way, your lease says you got 15 days to give us an alternative location that is at least as good for us as the one we gave you." Well, if there was a better location for them, they probably would have given it to you to begin with. So, how are you going to meet that term? The short answer is you're not. I just don't see it happening. So then how do you get in this spot? What happened? Why did the landowner agree to this? Well, one, they were under the impression in dealing with the landman that they had something that mattered, that they had some teeth to this. Well, my opinion, quite frankly, there's little, or there might be a half of a tooth, a baby tooth, the first baby tooth, and actually that's probably even giving it too much. There's really nothing there. So I said to the client, I said, and there's other problems throughout this lease, and I say, hey, did you have anybody look at this lease? I mean, did you consult with anyone? Did you have an attorney negotiate? Because there's a couple good things. There's some good things, but there's some big holes here, and some holes. One of the things when I look at leases, I can kind of tell that a landowner may have thought they had something of value, but really it's a throwaway provision. And this is a great example because this is a big provision on consent and location, but it ends up being essentially a throwaway provision. So I said, what did you do here? You have a lot of acres. This was a big money lease. Well, we had an attorney look at it. He read it over and told us it was good. And so is this like an oil and gas guy? Because it was a male. And they said, well, no, not really. It done some other things for us. And then I just put my hands, I just put my head in my hands. I'm just like, oh my heavens. Like, had you talked to somebody, had you talked to an attorney that understood this, that could have went through what I just talked to you about right now, well, maybe you could have had this as just at least a straight mutual consent and not all these caveats that you have to answer in 15 days. You have to supply a location that doesn't violate any laws or regulations, which could be a 15-acre area. If it includes a wetland of any kind, you could be stuck and not qualify. It has to be at least as acceptable to the client or to the gas company as what they present to you. And I would have said, look, you're never going to meet this. You need to shave some of this language out of here if you want to have this. Now, if the company rejects it and the company says, no, you take it or leave it the way it is, well, at least you know coming into this that, hey, I have a provision here that really doesn't mean much at all. So do I want to go ahead and sign this agreement? And that's when you start evaluating, well, there's compensation, there's a potential of future royalty. Maybe I can get something else in another area in these negotiations. So you're looking at those other issues. Well, these guys never had that evaluation because they never talked to somebody that understood what they were signing. So to sit there and have some attorney read this is just hilarious to me in a bad way, in a very bad way. But it's like, yeah, you read this document, you say, okay, yeah, this looks good. Well, how many have you read? Do you understand this? Can you explain this provision to me? How many people have you helped with development? What can I expect in the future? Ask those questions to that attorney. What can I expect in the future? You need to understand those things, because now there's no turning back. There's no turning back. So what are we going to do? We're going to look at where we have some strengths, where we can use this lease to benefit the landowner. In this case, what's funny, well, again, I don't know if it's funny, but there's some restrictions in here. There are some good things, and I'm very confident based upon my experience in dealing with the companies in this type of property in this acreage. There'll come a day where the company's really going to need something, and they're going to need permission, and that's when the landowner is going to remember how the landman made them believe that they had something more than they actually had. All right. I'm on a roll here now. I'm starting to get fired up. We have a short last segment, but I'm going to continue talking. I'm going to continue talking about landmen, talking about the prices, and very important. I'm going to rant a little bit here. It drives me crazy. People, we got to be smarter. We have to be smarter. I'm going to explain what I'm talking about after this break. You're listening to All Things Marcellus with me, Attorney Doug Clark, here every Sunday from 8 to 9 a.m. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Got a short segment. I just want to wrap up that last segment and say important things. One, the gas lease blueprint, the basis of so many future operations. You must obtain the best possible gas lease, or there's a strong chance you're going to be very disappointed in the future. You must get the best possible gas lease, and you must consult with, at bare minimum, and I recommend much more, but somebody before you sign that understands what the heck you're signing and what these terms mean. There are so many tricks. I can look at leases sometimes, there may be 20, 30 addendum, and only 4 or 5 of them actually mean something. You need to understand what you have, and maybe you go ahead, maybe it's weak, maybe you don't like a lot of things, but that's your only gas lease you're presented. And ultimately, you say that's in my best interest. But you have to understand that and then make an informed decision. Many times, there are better agreements that you could get. You just have to know to ask. Don't be afraid. Don't be afraid. A good lawyer, and this isn't just an advertisement for a lawyer, but a good lawyer is going to make up for any cost or expense that you're going to incur by hiring them. It is just the truth. Go look at my testimonials, whether you hired me or not, but just go look at the website and look at what people say. The people are saying, 100 plus people, hey, I'm so glad we contacted you. Not that I'm the greatest thing in the history of the world, but a good lawyer is going to make sure that you get the best possible agreement, the best compensation, and be way worth whatever cost there may be. Do not be afraid. I say quite often, my parents, I never even known of them ever to contact a lawyer. I grew up, people didn't like lawyers. I understand all of those things. But you're now faced with industrial operations and the potential of industrial operations on your property. You, whether you like it or not, need to reach out and get assistance from somebody that knows what they're doing, or you're going to get taken advantage of. That is happening. And, look, people know. Maybe you've already been taken advantage of. Your neighbors have. Nobody in the gas area has not either themselves or know somebody that's been taken advantage of, and it continues to happen on and on and on. I am Attorney Doug Clark. This is All Things Marcellus here every Sunday from 8 to 9 a.m. And I'm going to switch gears. Well, I'm on a roll here. And I'm going to talk, talking about Tioga County. Here's the thing, and I've said this before, but it keeps coming up. If a company landman or a company says, this is all we ever pay for these agreements, you need to check that. You need to check it. Remember, when you signed a gas lease, and all these people sign gas leases at $50, $100, and I understand that, and that was the market at the time. But you signed, and so many people were told. I can't tell you how many times I heard in negotiations in 2007, 2008, this is the most we paid. We're never going to pay any more than this. This is what we're paying everybody. Well, it went from $250 up to $6,000, $7,000. So learn from that. You know that. Most people have already experienced that. So when we deal with these pipeline agreements, roadway agreements, I don't care that that's the most that they say that they've paid, or we're paying everybody the same. Oh, this is what we want to pay to everybody. Well, yeah, if you're screwing over everybody, then, hey, we want to keep doing that. It's not, we're being fair. It's not fair to you, for the landowner, that everybody signed bad agreements. The company's argument is, well, since all these other people got terrible agreements and taken advantage of, we want to be fair to them and take advantage of you when you sign this. How ludicrous is that? How crazy is that? I keep talking about it, but it's happening all the time. I see it all the time. Here's a quick story. And I've told this before. Williams used to sign these agreements. They had a standard price of like $1,500 per acre for damages. I think it was $6,000 or so permanent for compensation, and per acre for compensation. Long story short, put it this way. It was about $15 per foot of pipeline easement. Oh, that's what we pay. That's what we pay. That's what we pay. Well, all these people signed at $15 a foot. Well, a couple years later, all of a sudden, across the board for everybody, Williams says, okay, instead of this $15 a foot, we're now going to pay approximately, I think it was around $25 a foot. Well, why are you doing that, Williams? This is a conversation I had with a representative from the land service company. I said, well, why is the price going up? Well, quite frankly, the market has changed. Well, what does that mean? Here's what it means. People quit signing at $15 per foot. People quit signing, so what do you have to do? Raise the price. Why am I talking about this? Tioga County, right now, their offers from Angelina are about $15 a foot. About $15 a foot. And they're going to be using the same arguments that they use in other places, that all these different companies use, that Williams uses, saying, well, that's what we pay people. That's what we pay people. Well, they pay people, same company, Susquehanna County, pays about double that. Is your land in Tioga County worth less? No. Is your land in Tioga County not as valuable to you? Absolutely not. So why is this the case? Because people are going to fall for these promises early on, and they're going to hear this, well, this is what we pay, this is what we pay. But I am extremely confident, fast forward a couple years, you're going to find that they're paying everybody a higher rate than that, because they're picking the low-hanging fruit. I hate to say it that way, but they're picking the landowners, and they're going to sign everybody that they can who's just going to sign whatever they put in front of them. So they're going to say, well, this is what we pay. This is what we pay. You don't need a lawyer. You don't need this. You don't need that. Well, what happens? You sign for $15 a foot, and what's going to start happening is everyone's going to be signing for a higher compensation rate in the future. They don't want you to know this. They don't want you to know this. If everybody stops signing or doesn't sign at $15 a foot, what's going to happen? Those prices are going to go up. Now, there are exceptions where you have these lines that go directly to a well site, but you can't fall for that either. You got to be careful, because although some things may be allowed under the lease, when you sign a pipeline right-of-way agreement, that agreement controls. So there's going to be, almost in all cases, more things that can occur. That's where you need to get help to decipher this. But in the most cases, in a lot of cases, in most cases, the landowner can say no or negotiate a higher price. I can't tell you when was the last agreement that I did for $15 a foot. I have not done an agreement at $15 a foot for years, to my knowledge. Years. And now, all of a sudden, everyone's being asked in Tioga County to agree to a $15 per foot right-of-way agreement. Why? Why? Well, the only reason why is because that's what people will sign for. Well, people, be smarter than that. And you don't have to, just get market price of what's being paid across the whole region. Don't say, well, okay, well, this is what they're paying, so I'm going to go ahead and sign it. You can't do that. You need to get assistance. You can't be taken advantage of. They're paying double that in other areas. Drive an hour away, probably, and you can get double in that. In some places, even closer. Don't fall for that. Just because other people signed bad agreements doesn't mean that you should too. Just because other people signed bad agreements does not mean you should too. The landman works for the company, not for you. You can't trust that they're giving you the best possible deal. Why would they? Why would they? All right, I got to go. Up against it. You're listening to All Things Marcellus with me, Attorney Doug Clark, Clark Law Firm, here every Sunday from 8 to 9 a.m. Check out PAGasleaseattorney.com and have a great week, everyone.